It's Entertainment Law Update, episode 171 for August 28th of 2024. Well, hi, everybody. Welcome to Entertainment Law Update from Los Angeles, California. I am Gordon Firemark.
And from the Dallas-Fort Worth Metroplex, I'm Tamara Bennett.
And we are, as always, glad that you are here with us for this episode. This is our podcast about entertainment law, where each month we pull together a roundup of legal and business news stories and share our opinions and our commentary and analysis and a little chit-chat. So let's do the chit-chat right now. Tamara, what's new?
Chit-chat. So my child's moved to Iceland.
Oh.
And we're for a semester, and Johnny and I are planning to go to Iceland 1st of September for a week. So we could not get more than a week to go. So we had a little over a few days over a week. But that's, I think, our most exciting news. It's
cool. Is that
never been to Iceland?
Is that volcano still erupting in Iceland, or is that settled?
So no, it decided to erupt again on Sunday.
Oh, okay.
We got a text message with a picture, and I'm like, oh, I just thought it was the sunset. Johnny zooms in on it and then replies back and says, is that a volcano?
Oh, wow.
And yeah, so
well,
he's far away, and we don't have to be that close.
Well,
so hopefully everyone is safe. There's been some other things in the news about some ice caves and people dying, unfortunately. So,
well, he's got a good head on his shoulders. He'll take care of himself while he's there.
Yes, we hope so. We hope so. That's the plan. He is enrolled in school. He has a place to live, and now he needs a job.
All right.
So,
Well, my kids have gone back to school, and I can't tell you what a relief it is. It's been great having them around this summer, but it's also great that they're back to school and they're thriving and doing well. And I have 2 in high school now, so I'm confronting my age. I got started a little later in life than you did. So
yes.
Anyway, let's talk about some upcoming. Well, first of all, I'm just back from the Podcast Movement Conference in Washington, D.C. It was nice to be in Washington, D.C. while the Democrats were in Chicago. I guess you could say the town was relatively calm and comfortable. So anyway, it was a good conference and had a good time, and also glad to be back. So
good. Well, we're glad you're back, and so I'm sure no one else can figure this out. But in case I don't know, I'm a little slow on my end on my connection, so just making sure everything is good on your end.
No, it's looking good, sounding good. We'll keep going.
Okay, perfect. We'll keep going, everybody. So yeah, you're back from that conference, and then I don't know if you mentioned we've got another conference coming up.
No, that's what I was getting at. Is we've got in November. What is it? November 20th through 22nd. We'll be in Austin for the University of Texas, the Texas State Bar Entertainment Law Section conference.
UT Law School CLE puts it on for us. This is the second year they've done that, and Entertainment Law Institute in its 30-something year of the actual conference. Sorry, I don't remember the exact day, but it should be fun. They're doing a 101 day on that Wednesday in November, and then Thursday and Friday will be, at least 12 hours of entertainment law related CLE.
Right on. Are you presenting?
I am not presenting. Okay. I'm on the planning committee this year, so involved in that way and happy to do that.
And I will be joining a panel about the union deals that came about at the end of last year and the impact they've had on the industry. So that'll be a good one, I think, a fun one. And then are we recording a live episode in front of the studio audience, or is that not?
We are not doing that this year, but we'll figure out when we can record. We could maybe do one in person while we're there.
Maybe,
So we'll figure that out.
Okay, great.
That's good.
Well, great. Well, we have a busy rundown today, so I think we should just jump right into our content. And let's talk about that NFL verdict that we mentioned in last month's episode. Looks like the judge has now overturned that $4.7 billion verdict in that class action suit over the Sunday Ticket subscription series. The NFL was granted a judgment notwithstanding the pleadings, I guess, or notwithstanding the verdict, I mean. And the judge ruled that the testimony of two witnesses on the subscriber's side of the case had used flawed methodologies and should have been excluded. He issued a 16-page ruling agreeing that the testimony of Dr. Rasher and Dr. Zona was based on flawed methodologies and should be excluded. And because there was no other support for the class-wide injury and damages elements, judgment as a matter of law for the defendants is appropriate. And he conditionally granted a new trial, but there was some interesting language. So just a little bit of background. The case was first brought in 2015 and focused on the package of games outside the local market that are not shown nationally on other networks. Attorneys for the plaintiffs argued that by restricting broadcasts of those out-of-market games only to those who subscribe to the package, the NFL was essentially forcing customers who just want to watch one team or a small group of teams to pay more than they should. And it covered 2.4 million residential customers and 48,000 businesses around the country who had paid for the package on DirecTV. And that was in the 2011 through 2022 seasons. So the jury in June had awarded $4.7 billion in damages, ruling that the NFL had violated antitrust laws and distributing out-of-market games on a premium subscription service. And, found them liable for 4.6 or so in damages and $96.9 million to the commercial class. And because it could be trebled under federal law, it looked like it could go as high as $14 billion or something. But the judge said, no, the jury didn't even follow his instructions. They relied on inputs not tied to the record to create its own overcharge. And apparently the jury's amount didn't refer or didn't conform to either of the two expert witness models either. So they presented them with two flawed methodologies, and then the jury went and created a third, essentially.
Yeah.
So,
and again, this has been going on since 2015.
Yeah, nine years of litigation.
Yeah.
And anyway, so the judge said in his decision that if he hadn't ruled for the NFL as a matter of law, he would have vacated the damages verdict and conditionally granted a new trial based on that irrational damages award. So I guess the NFL wins.
I guess they do.
Yeah.
I'm sure it's probably not the end of it.
It's interesting. That bundling thing, there are a lot of legal questions about it, but something was stinky in the way it was done, I guess. Anyway, the way the case was brought. We have a lot in the AI arena this time around. Well, first of all, I just want to tell you about a new resource we've discovered. Baker Hostetler, respected law firm, has a new case tracker, and we've got a link to it in our show notes, but the link is the bakerlaw.com/services/artificial-intelligence-AI/case-tracker. Anyway, you get the point.
You can find it. And it looks like it's limited to intellectual property AI tracking.
Yes.
I know at one point, and I need to go back and find that resource, we had a link to a source that had a lot of other areas of law in AI, like criminal-related AI cases and that kind of thing.
Oh, yeah. We'll try to drop that in the show notes as well.
Yeah, I would like to go back because I'm just curious, kind of, since we don't follow that every day, what's popping up in things related to AI, but not related to IP specifically.
Yeah. Well, one of the big cases in the AI arena, AI IP arena, is the Anderson copyright lawsuit. This is Sarah Anderson et al. Versus Stability AI et al. This is visual artists, Sarah Anderson, Kelly McKernan, Carla Ortiz, and others, class action against Stability AI, Midjourney, DeviantArt, and Runway AI, alleging that the software Stable Diffusion was trained on their copyrighted artworks without permission, that it enables the AI to produce images in their styles. And the plaintiffs claim that Stability and Runway scraped 5 billion images into data sets to train the tool. They argue that Midjourney also used Stable Diffusion for training, leading to copyright infringement through that system's output. and use of their artistic works. So the Judge Orrick, has issued a mixed ruling on the defendant's motion to dismiss the claims brought by the artists. And initially he had dismissed the original complaint, but found the amended complaint was sufficient to allow the copyright claims to proceed. Focused on allegations of compressed copies of training images and theories of active inducement to infringe. But he did dismiss several claims with prejudice, including those related to the DMCA, copyright management information, contract breaches, breach of an implied covenant of good faith against deviant art. But the judge did allow crucial claims of copyright infringement and Lanham Act violations to go forward. He also scrutinized Stability, Runway, and Midjourney's motions to dismiss and found the plaintiff's allegations in those cases were plausible enough to allow the copyright claims to go forward, especially the theory that the models store compressed copies of training images that can recreate the originals. So also
that's interesting.
I think that's going to come down to a lot of proof and probably expert testimony about the nature of the ingestion and what happens.
Right. And how, well, to me, it's Perfect 10 2.0.
Yeah,
that's got to be what the basis is. How quality, but today, again, in Perfect 10 2.0, the quality of a compressed image today is very, very different.
Yeah.
Wouldn't you say, than the quality of a thumbnail image from...
And I would say also that in the AI cases, there's a question of, is that compressed image actually an image, or is it some interpolated computer shorthand for the image of some sort? So
has it been, quote, transformed?
And is that fair use? Yeah, exactly.
Yeah. Oh, I hate it when we think through these things.
Well, and either good or bad that neither of us is actually representing any of the parties in these cases, but hopefully the legal minds on this will have thought of these issues themselves as well.
They will have thought of through all.
If not, they'll listen to the show and they'll get it from there.
That's right, and they'll be like,
You're
"Yes,"
welcome.
and we will get a footnote. We would like a footnote in your pleading.
There you go. Also, on the Lanham Act claims, this was interesting. Apparently, Midjourney misused artists' names in promoting its services.
That.
So that could be, maybe that's where they really end up hanging their hat. I don't know. Anyway, so the case now moves into discovery and toward trial, obviously. And this is a pretty, big step in the ongoing legal battle over copyright infringement in the AI arena. Also note that the first of the AI copyright trials began last Friday. It's only expected to go, I think, less than 10 days of trial. That's the case involving Thomson Reuters over the ingestion of the head notes.
Okay, and that's the case that we talked about, I know for sure, last November when we were doing the live episode of the podcast in Texas.
Yeah, so
it had just kind of really ramped up then. And now it's going to now it's in trial.
Well, as of last Wednesday, it was slated to start on Friday. I haven't heard any news otherwise.
Oh, it may not have gone. Okay.
Well, I mean, I think it probably is at trial. And I think that's in the D.C. Circuit. I'm not sure. Anyway, so possibly by next month when we do our show, we will know a verdict in that case and have something to talk about.
Yeah, and if a listener has a heads up, already when they're listening, shoot us a... How do folks send us something, Gordon? They can send you an email,
They can email us. The email is entertainmentlawupdate@gmail.com, or send us a tweet at entlawupdate, or head on over to entertainmentlawupdate.com and there's a little voice widget, a little red tab on the side of the screen. You can click and talk to us, and we can play your recording on the show. That'd be fun. So. Well, the ABA has come up with some guidance on how to use AI in legal practice. Nothing much to report. We're not going to give you a summary of it here, but you can go find it. Our links in the show notes will take you right to that ABA Opinion 512, as well as a couple of articles about it. So,
Yeah, and check and see if your bar association or your malpractice carrier has issued something about that. I am just going to throw in, because it kind of ties into the next updates we're giving. It's really, are we competently using AI? Are we independently verifying? Is there confidentiality issues? And how are we communicating to our clients that we're using AI?
yeah.
Um,
Well, that's an interesting area. I
so
hadn't thought about that aspect of it.
Right. Yeah. And so, so the USPTO has also issued guidance on AI tools for patent and trademark practitioners.
Yeah.
This was back in April. They issued guidance. And again, this is all dealing with generative AI.
Yeah.
Because I suspect you and I both, and most all other lawyers, have used other types of software and artificial intelligence for years to process information, but we're not saying, write this pleading on XYZ, in which we know the AI hallucinates often and makes stuff up. So while using generative AI and preparing submissions to the USPTO, a practitioner has a duty of candor and good faith while dealing with the office. We are responsible for checking the AI's work to make sure the statements are true, citations are accurate. That's where, when we've done tests, or I've done test runs, it tends to make stuff up. And then this is specifically related to patent applicants, a duty to disclose that all patent applicants abide by if the AI tool is used in any way before the USPTO that is deemed material to patentability.
Oh, interesting.
Patentability. You and I are not patent lawyers, so if you're a patent lawyer, go read that. AI tools are permitted to access the USPTO IT systems, but are cautioned against data mining of the records. In some, the guidance reminds practitioners that while AI is permitted, practitioners need to be diligent and adhere to established rules. And I'm just going to throw something out here and ask, have you seen or used any of these kind of custom chat GPTs that are specific to an industry or a subject matter? It could be legal, it could not be legal.
Well, I have created my own sort of custom chat GPT for one of the podcasts I do, the Legit Podcast Pro. It helps me outline and summarize things for my what eventually becomes my script. I don't trust it to write the whole script, but it's good, at that. And it's really, that's just about knowing my voice and how I like to do things and what I want the output to look like. I'm trying to think if I've used any of the other sort of, and there's a bunch of custom ones for specific kinds of outputs. But, there are AI tools for lawyers specifically that I'm told are not hallucinating. It's interesting. I heard a different phrase for, things for like shepherdizing and verifying citations and things like that,
right,
where it will only rely on verifiable data and stuff like that. And I think you can even sort of teach ChatGPT to do, please don't use any imagination on this. Just give me the real stuff. You still have to fact check it, of course, but you can, tell it, I don't want anything that's not sourced from multiple sources, things like that.
Right. So yeah, it was interesting. So I've been learning more about using generative AI unrelated to the practice of law, but because I've been doing a lot of genealogy research, and
cool.
It's fascinating. I'm like, oh, this is such a great way to learn a new resource and it not be bogged down with work. So there's lots of these custom made chat GPTs. And so then I got to thinking, well, if there's all these related to helping you with genealogy, gosh, wouldn't it be great if one of them had ingested all of the trademark manual of examining procedure, and you could tell it only pull things directly from the TMEP and don't hallucinate. It looks like there's some people out there who have created things that might do that. I was like, Tamara, you probably don't have to create this. So, which leads to the question is, how is that any different than the fact that I bought a book when I first started practicing law that was that big and had a CD And it said, if you're arguing likelihood of confusion, here's all the cases you
Right.
need to argue. I still have to go verify
Yeah,
that
and
they
update.
are
Make sure you're up to
accurate
date.
and
Sure.
update. That's right. And cite
Hmm.
and so on and so forth. So I ran some test runs and got some gibberish, but overall I was like,
Yeah.
that's kind of what I would have said. So, right. But then the question becomes, based on these ABA rulings, your local bar rulings,
Hmm.
the USPTO, in addition to candor and verification, is there something where I might have to, if this is material to the outcome, what have I got to really disclose to a client?
And to the
Uh,
USPTO or the court or whatever,
yeah,
So,
yeah, yeah. So there's some good tools.
sure.
Um,
And I think some of the legal specific ones are they are not programmed to be imaginative. I think that was the alternate phrase I heard for hallucination was, hey, we designed these systems to have an imagination or an
yeah,
approximation of an imagination.
we're lawyers. There's no imagination involved.
Well, creativity is not the same as
Uh,
imagining outcomes.
but the other thing I question about is
Mhm.
confidentiality. So if we're loading up information into this, are we somehow disclosing confidential information?
Yeah, that's a great question. I think that's the caution to us is don't. You can ask the questions, you can do the research, you can have it prepared, draft, maybe even that kind of stuff. But at some point, you have to sit down and safeguard the client's information.
Yeah.
Although, if the information shows it well, that's in the inputs, because again, it's always learning from what you put in.
Right. And that's
Yeah,
my concern.
yeah,
So, even though a office action, say with the trademark office, is public record, I mean, anybody can
right.
go look at the office action.
Yeah, but
Am I restricted from uploading that office action to Chat GPT and saying you are a expert in
mhm,
trademark law,
yeah,
analyze and bullet point the issues raised?
yeah, yeah.
I, I don't know. I don't know the answer to that.
Or if you tell it, hey, I've got this fact that works against me, please craft an argument that addresses this particular, and then you decide not to use it or something. Now it's still in the system somewhere. So, um,
Yeah.
who knows? Anyway, uh, continuing on with our AI summaries, we have video game performers have now authorized a strike over AI concerns. The union, that is the Screen Actors Guild, SAG-AFTRA, have voted the 2,500 SAG-AFTRA off-camera voiceover performers and on-camera motion capture stunt performers, coordinators, singers, dancers, puppeteers, background performers, and so on. They were looking for wage increases to match to keep up with inflation, medical treatment and breaks for motion capture performers, and looking for more protections for those folks. You've seen these black suit with the white ping pong balls or white dots all over the markers and sensors on a bodysuit. That they're looking for some more protections there. And a spokesperson for the studios, Audrey Cooling, said that they had reached agreement on 24 of the 25 proposals, including those wage increases, safety provisions, and so on, but not on the AI. She said that the studios offer extends meaningful protections, but SAG-AFTRA's negotiating committee said the studio's definition of who constitutes a performance is really key to understand the issue of who would be protected. And the industry has told us point blank that they do not necessarily consider everyone rendering movement performance to be a performer covered by the collective bargaining agreement. That's from the SAG-AFTRA chief contracts officer. And also said that some physical performances are being treated as data. So the union says, no, without guardrails, game companies could train AI to replicate an actor's voice or create a digital replica of their likeness without consent or fair compensation. And so the actors are going to go on strike. They are on strike. We strike as a matter of last resort, they said. We've given the process as much time as we responsibly can, exhausted the other possibilities, and that's why we're doing this now. And amid all of this, SAG-AFTRA created a separate contract last February that covered independent and lower budget video game projects, the tiered budget independent interactive media agreement, that's a mouthful, contains some of the protections that the industry titans are rejecting, and games that are signed to that interim interactive media agreement and tiered budget agreement are not a part of the strike. So it's a limited strike. My understanding is the union expects this strike to go a very long time. They're predicting a year.
Wow.
So we'll see. We'll see. That could hurt them in the long run. It could shoot them in the foot, because if the AI tools are up to the task of replacing some of these workers, they may find themselves replaced, by AI scabs, essentially.
Oh, wow.
So who knows?
Well, and this is your topic, part of your topic.
Yes, it is.
In November. So we will get the latest and greatest by then.
Well, and this strike will likely still be going on in November, according to the union's predictions. I wonder if we should get Zach to, maybe he's got some insight here from the whole game perspective. I think that would be, we're talking about Zach Strebeck, a former member of the Entertainment Law Update team. Zach, if you're listening, reach out to us. And if you don't, we'll probably reach out to you on all of this. And Zach is a relatively new father, so let's just congratulate him for that as well.
That's right.
So they had a baby, in the last 9 months or so. So yeah. Anyway, so the union strike is apparently on. Haven't heard a lot of news about it in the last few weeks, but it was authorized in late July, I think, and that's where we are now. So,
got it. So the Copyright Office is also in the mix on giving us some AI reports and updates related to digital replicas. This is the first part of the U.S. Copyright Office Copyright and Artificial Intelligence report that came out in July 2024. Digital replicas are AI-generated replicas of an individual's appearance, voice, other personal attributes. And the report highlights key findings and recommendations related first to legal and ethical concerns. It identifies significant concerns regarding unauthorized, that's always ticket, isn't it? Unauthorized creation and use when the individual has not consented, along with could there be privacy issues involved and violations of other IP rights. The Copyright Office recommends enactment of new federal legislation. As well as the report emphasizes balancing the protection of individual rights with the need to encourage innovation in AI technologies. And I love this. And we need to do some further research and analysis. The findings and recommendations are part of the ongoing effort of the Copyright Office to address the complex legal issues posed by AI and copyright law.
Oh, very interesting. Hey, the balancing innovation and rights just got me thinking about the copyright or intellectual property clause in the Constitution. And I'm asking myself, could the Congress make a separate AI law just based on that authority to preserve for artists and inventors the exclusive rights to their works for limited times? I don't know. Anyway, it's just popped up.
There you go. Well, but I think that is part of what the copyright is designed to do. Obviously, that's why we have a fair use portion of the law, is because we have to, and we're going to talk about this as we move along, fair use and First Amendment and copyright, and how does that all play together? There is a balancing of innovation and rights.
And I dare say the Commerce Clause also could justify some legislation on this. So there's lots of basis for Congress to act if the will is there. And I think it is actually. And
they have been doing some acting. They've been doing some proposing of new legislation.
In fact, the No Fakes Act has been introduced. It is the Nurture Originals, Foster Art, and Keep Entertainment Safe Act, No Fakes, which provides a new right to enable people to stop the unapproved use of their likeness and voice in the context of AI. Introduced in the U.S. Senate, the bill has very similar in context to the No AI Fraud Act in the House of Representatives, introduced back in January, which empowers individuals to request that deep fake content featuring fake images of themselves be removed from platforms, and establishes the right of these people to sue when their right of voice or likeness has been violated. So the Senate version also extends those rights to families of deceased persons and to protect their loved one's voice and likeness. So this is a potential federal right of publicity in the AI arena world statute. Interesting.
Right. And it kind of, they brought up Tennessee's Elvis Act.
Yep.
The No Fakes Act includes provision to ensure that state laws will not be overridden by federal legislation as long as those state laws are in place as the beginning of 2025.
Oh, that's an interesting.
So that's interesting.
Yeah.
I haven't. I'm looking at, well, sorry, my watch has the date on it. The clock be a ticking.
There's not too many acts that are going to go into effect, I think, before, January may be the operative date for a number of them. We don't know what all the states have going. So,
yeah.
There's another bill addressing this also in the Senate. Representative Adam Schiff, in the House, Representative Adam Schiff has introduced the Generative AI Copyright Disclosure Act that would require AI developers to notify the Register of Copyrights about any copyrighted materials used to train AI algorithms. That's kind of interesting. I don't know exactly how much good that does, but we'll see. And then we also have another one called the Copied Act. On July 11th, Senators Maria Cantwell and Marsha Blackburn and Martin Heinrich introduced the Content Origin Protection and Integrity from Edited and Deepfaked Media Act. We should have a law against these acronyms. It's cute, but anyway, this law would create standards to help prove the origin of content and detect synthetic content, like watermarks and things, in an attempt to protect the integrity of journalistic and artistic content. Proposed security measures would prevent the use of materials without the creator's permission and prohibit tampering with authentication markers. The FTC and state attorney generals would enforce the act, and private rights of action could be taken up also. So at first glance, it seems to address a lot of AI issues that creators are facing, but it also targets content that uses AI-based spelling and grammar systems and things like that, and broadens the enforcement unnecessarily into things that would otherwise be deemed fair use. And a lot of the covered content will include content currently in the public domain. So that's kind of interesting. And it ties into an argument in one of the cases we'll talk about in a few minutes. But so that's just something to keep an eye out. The article that we have linked here actually raises the question saying that the Copied Act is an end run around copyright law. And I will leave it to you to judge.
And it may be something that could just be preempted.
Yeah.
It might be a preemption issue. We've also got the Restore Act on July 31, 2024. Senators Chris Coons and Tom Tillis introduced the Restore Act. Anybody want to guess on what that acronym stands for? I got to read it. Realizing engineering, science, and technology opportunities by restoring exclusive patent rights Act of 2024. Hey, we've got a couple of patent comments this month for our patent attorneys who are loyal listeners and watchers. The goal of the Restore Act is to restore the presumption that a patentee who has prevailed against an infringer at trial is entitled to an injunction, subject to principles of equity and public policy considerations. Section 2 of the Act sets forth findings for which Section 3's remedy is based upon. Section 3 of the Act aims to amend Title 35, Section 283 of the U.S. Code to provide a rebuttable presumption. If passed, this amendment would return patent litigation to the state of affairs prior to the Supreme Court's decision in eBay versus Merck Exchange. In that case, the court removed the established presumption of that right of injunction. Commentators believe the lack of a presumption of an injunction has motivated efficient infringers who see the penalty they would pay if found to be infringing less costly than obtaining a license.
So it's cheaper to ask forgiveness than permission.
That's right, than permission. So if we've got that patent summary wrong, you guys let us know. But we want to make sure you have all your acronyms
Yeah,
for all your proposed legislation.
I confess I wasn't aware of that change from the eBay versus Merck exchange ruling that took out automatic right to or presumption of the right to
and that's a big deal, and we would not want that to bleed over in copyright and trademark. And
well, yeah. So here we have at least the hopes that this Restore Act would restore the injunction. Thing. So the EU AI Act has taken its effect. It went into effect on August 1st. It applies to entities both in and outside the EU, so that's why we have to pay attention. The EU AI Act pertains to a variety of entities, including providers, deployers, importers, distributors, product manufacturers, and more. The Act concerns AI systems and general purpose AI. The former is a machine-based system designed to operate with varying levels of autonomy and that may exhibit adaptiveness after deployment, and that for explicit or implicit objectives infers from the input it receives how to generate outputs like predictions, content recommendations, or decisions that can influence physical or virtual environments. That's a mouthful. General purpose AI is defined as an AI system based on a general purpose model and which has the capability to serve a variety of purposes, both for direct use as well as integration in other AI systems. So the regulation sets up this 4-tiered risk-based approach with penalties like fines for entities that violate AI practices under Article 5 and entities that violate AI practices outside of AI of Article 5 as well. So the Act continues to take root, but there are some key dates in 2025. If you look at the link we're providing, you can find out more about that.
Yes, and then I will ask my resident student who's studying in the EU, media and business and ethics, if he's getting any current updates on EU AI legislation as part of his coursework. So we might have a more on the boots on the ground take on this as it moves forward.
I just had this funny thought. I said, well, you could always ask AI to summarize the European AI rules, but I wonder if you would find a bias in the output.
I don't know. I don't know. And something we talked about, gosh, I don't know when the executive order came down from the White House. Was that
sounds like it was January to something like that. Yeah.
I feel like it was earlier than that. But anyway, on July 26, 24, the White House joined in stating that the federal agencies have completed everything in President Biden's AI executive order ahead of the set deadline. One notable focus of this was the creation of open source software to help test how AI models and systems respond to adversarial attacks. The software is meant to stress test what happens when someone tries to poison the training data. So that's kind of interesting.
So the executive order was 270 days prior to this announcement, which was July 26th. Okay. So you're right. It was longer ago than January.
Yeah. So it was the end of 23 then.
Yeah.
Okay.
So I think we alluded to this a little bit ago. The DC Circuit has rejected the idea that DMCA anti-circumvention and anti-trafficking provisions violate the First Amendment in that they are overbroad and therefore unconstitutional. This is Matthew Green versus the Department of Justice. Green is a computer scientist and professor and tech inventor challenging the DMCA regarding the anti-circumvention rules in there, and of course the Department of Justice. So Mr. Green sued to challenge the prohibitions under the DMCA on circumvention as violating free speech because it stifles fair use. So in the AI world, that means that if AI used tools that would read protected files, encrypted material or something, that would be a potential infringement, even if we assume that use is otherwise a fair use. Another one of the plaintiffs, Huang, was going to create a special program and device that would allow users to save, manipulate, convert, and edit HD video streams. Now, if you've ever tried to take a screenshot of a frame from a Netflix show or something like that, what you get is a black screen. So there are these countermeasures in place to prevent that kind of piracy. This device would have essentially undone that and made it possible. So the goal here would be to, maybe you create a side-by-side comparison of scenes from two films, or a debate and a commentator, something like that. And, they're saying that's fair use. We should be allowed to do it, even if we have to circumvent these anti-copying tools. So the court said no, anti-circumventions are not a restriction on speech. They're a restriction on conduct, and that the First Amendment doesn't protect conduct. So as it pertains to fair use, the court noted that it wasn't as if anti-circumvention was illegal per se, but rather, libraries might use these tools to determine whether to make a copy or not, and there are rules regarding these circumvention efforts. Fair use remains an excuse for circumvention efforts, perhaps, but the key factor is that these are not there to prohibit the making of the code, but rather the action of breaking the anti-circumvention encryptions. So it doesn't have a reasonable – anyway, the court generally notes that the types of activities they wanted to allow are permissible, but under different sections of the code, like access of clips for making a documentary, but not for fiction. Anyway, lots of examples. Plaintiff argued that the First Amendment includes a right to access and learn, but the court stated that that is a right to read, but not a right to read everything you may wish. So speakers could still control their own speech. And so just because you can't grab exactly what you want for free doesn't necessarily make it a prohibition on speech. By that plaintiff's analysis, for example, this is my thinking now, that would essentially give anybody the right to translate a work from one language to another because, hey, I've got a right to read it. And translation is a derivative work. So
that's right. And I'm just listening to you walk through this summary, and I'm thinking, how does this all then relate to the stability AI?
Yeah. Interesting question.
Yeah. I mean, I realize these professors I kind of read up on one of the professor. He's does really cool stuff. As far as his ability to program write software that does what this software does.
Mm-hmm, mm-hmm. Yeah, I mean, so, I think that to the extent that the AI companies are arguing what we're doing is fair use, by extension, this argument that, and since it's fair use, the anti-circumvention laws are violating our free speech or our First Amendment rights. That could take us down a path. Here we have the DC Circuit, a district judge saying no. The anti-circumvention or the circumvention is an act, not a speech, and so making a law that prohibits that circumvention is not unconstitutional.
Okay, so is it an act for me to load up hundreds of thousands of books and images and third-party owned copyrighted works into a large language model learning system?
Well, I think the act in question is breaking encryption on that material if such encryption is in place.
Okay. In relationship to...
Yeah, because what the DMCI says is to the extent that we have data management, what's it called? Data management...
CMI.
Copyright management information. That removing that would be a violation, right? And that's an action. That's not speech, is what this judge is ruling. Okay. So, I guess what he's also saying is we're not saying you can't write the software that does it, but then you can't use it. So the speech is the writing of the code. And the action is the implementation or the application of the. It's an interesting bit of hair splitting, and it'll be interesting to see if other courts follow that reasoning.
Yeah.
So
that is why Gordon is Professor Firemark.
I'm not that kind of professor.
Well, he is the teacher.
I'll own it. Okay, I'm Professor Firemark. Anyway,
you own it. You are a professor.
So. let's talk about Vedder versus Resnick. This is an interesting.
Oh my
Take it away.
gosh,
This is
this. Well, maybe I'll school us on this
there.
one.
You go.
But so I will, and also in full disclosure, I took this case and loaded it into
Mm-hmm.
ChatGPT and said, make me a timeline. I'm
Mm-hmm.
sorry I don't have in here what all my prompts were because the first two or three prompts
Yeah.
were not good.
Mm-hmm.
This is a great use for a chat bot, a
Yeah.
generative AI, is you give it the exact information and then have it organize it
Mm-hmm.
for you. Um, and I almost wonder if the judge was hallucinating, but we'll move along. So in 1962, two songwriters, Mr. Vedder and Mr. Smith, co-authored the song Double Shot of My Baby's Love. In 1963, they assigned ownership to Windsong Music Publishers. All of their interest, yeah, I love that ChatGPT wanted to point out they did that for $1,
Mm.
but we're going to also assume that they were in turn receiving all of their
Yeah.
royalties for that. Windsong transferred some rights in 1966. The original copyright was registered with a term of 28 years. This is under the
Mm-hmm.
1909 Act. So the original term was 28 years, and then you had to renew your copyright for another 28 years. Co-writer Smith passed away in 1972, and I thought it was fairly settled law. You can go look at the Tom T. Hall
Mm-hmm.
case on that if you don't survive into the renewal period, then your renewal rights were contingent and could not vest in the publisher, and they vest in the Smith's heirs. And I think that part, as far as it vesting in Smith's heirs, is what they court
Yeah.
said. Renewal copyright registered in 1994. So that was registered in Smith's heirs
Mm-hmm.
as well as the co-writer Vedder. Obviously, Vedder's share is owned by the publishing company.
Mm-hmm.
So Windsong holds 50% of the renewal interest. Smith's heirs own the remaining renewal 50%. 1996, there's some ownership transfers here and there and back and forth. We go up to 2019. The Vedder share issued a termination notice to Windsong and the other co-publisher
Mm-hmm.
under Section 304 of the Copyright Act to recapture the rights initially granted back in 1963. Pre the termination notice, the argument is that Vedder owned 50, Windsong, now owned by Resnick, who's a party to this suit,
Yeah.
owned 25, Liar Song owned another 25, and that in May 3rd, 2022 is the effective date of this termination notice. We've talked about many
Mm-hmm.
times in here that there's a very specific window and a process for filing this copyright grant termination notice. So post-termination ownership claim, Vedders retakes ownership of his original authorship share, but defendant Resnick Music is claiming a 25% interest ownership despite the termination notice. And then we have this issue coming up in front of the judge that, as a party who represents authors and heirs, I'm really excited about.
Mm-hmm.
As a party who represents the
Mm-hmm.
assignee of these rights, I'm a little confused.
Mm-hmm.
It's coming out of Louisiana. The plaintiffs filed this suit, and the defendant filed a motion to dismiss, and the court denied their motion. The case is challenging the prevailing view that copyright termination results in a recapture of U.S. rights only. That's how it has been applied.
Yeah.
And my question is this lawsuit setting out to make new law in two areas? One, on the scope of a renewal copyright. Count one of the complaint addresses whether Vedder Communications renewal copyright interest that they acquired from the Smith heirs, including the right to exploit the song globally, not just within the United States. The plaintiffs argue that the renewal copyright covers global rights, citing the U.S. Copyright Act of 1976 and 1909, which are aimed to provide the author's family with a new estate, quote, upon renewal, or another bite at the apple, is the way I've always heard it discussed, with implying that this is not geographically limited. The plaintiffs contend that the new estate includes global exploitation rights and not just those rights of copyright exploitation within the U.S., that the Berne Convention and other treatises extend these renewal rights to encompass rights globally. The defendants, the publishers assert that only domestic rights within the U.S. are subject to this renewal and reversion, and foreign rights remain vested and non-contingent, arguing Supreme Court case of Stewart via Bend, which held that an assignee holds no rights if the author dies before the renewal period begins, as those rights revert to the heirs. The defendants interpret Stewart to mean the only U.S. renewal rights are contingent, while foreign rights remain with the original assignee. Foreign rights remaining with the original assignee on renewal has been the way it's been working. The court, however, finds that plaintiffs' arguments that somehow these renewal foreign rights they find it plausible, suggesting that the renewal copyright likely includes global rights, aligning with legislative intent to provide the author's heirs with a, quote, new estate, which could include both domestic and foreign rights. That's the renewal term. Termination rights under Section 304 permits authors to terminate certain previous grants of rights in a renewal copyright, providing them with a second chance or that second bite at the apple to benefit from their works, especially when they have been initially transferred for inadequate consideration. They all signed bad deals in the 60s. That's Tamara's note.
And that's the Superman story, again, Siegel.
Yeah. I mean, there's many of those. Section 304C6E introduces a limitation stating that termination only affects rights covered by the grant that arise under this title. So the rights are arising under the U.S. Copyright Act and does not impact rights arising under any other federal, state, or foreign laws. So the defendants, the heirs, are arguing that the limitation confines termination. The publishers are arguing it confines termination to domestic rights within the U.S. The Siegel, Warner Brothers, Superman case, Fred Alhart Music versus Warner Chappell, and concluding that foreign rights are governed by copyright laws of other countries and remain ineffective. So the way these terminations have been working for the whole time we've been able to actually have an effective date of termination is that you, the heir or the author, if they're living, is negotiating to reclaim their U.S. rights only. Again, as someone who represents authors and heirs of authors, I'm kind of excited. Could we potentially get everything back? The plaintiffs are arguing that foreign protection for U.S. works arise from international treaties like the Berne Convention, which mandates that countries recognize copyrights originating under U.S. law. And since these rights are recognized through these international treaties and agreements, those rights arise under this title, meaning termination should apply to both domestic and foreign rights. The court finds the plaintiff's argument along that line plausible, noting the termination rights purpose is to give authors a second chance to benefit from their work, and limiting termination to domestic rights only would frustrate this purpose, especially in a globalized world where international exploitation of works is significant. So the court suggesting the foreign rights recognized under international treaties due to U.S. copyright protection may indeed be subject to termination. That's kind of a drop the mic moment in the world of copyright grant terminations. And my question is, are the plaintiffs trying to make new law? Prevailing interpretations generally limit copyright grant termination to domestic U.S. rights only. Again, looking at the Copyright Act, sections 203 and 304 of the U.S. Copyright Act. And I say it will have a significant impact, and depending on which side of the plaintiffs or defendants you're standing on is how you're going to feel about that significant impact if this moves forward in some way.
Is there no appellate level ruling in any of the federal circuits that addresses whether or not the international right. I mean, it seems like this has been going on long enough that someone must have brought this up in a court somewhere.
I don't know. I need to dig deeper and see if we have. Well, I mean, the Tom T. Hall and the family on all of their renewal rights, that was an appellate court decision out of the Sixth Circuit. Obviously, the cases we just cited, the Superman case is an appellate court decision.
Yeah, I just have none of them brought up this specific question of does it cover the international as well? Where did we get the idea?
Or has everybody just
operated
said that's the way it is, operated under that way?
Hard to believe.
I don't know. When I have more time, I will be doing the legal research. But comments from around the web. Quote, breaking with existing precedent and adopting a, quote, novel theory of recovery, district court holds the statutory termination of copyright grant as well as contingent copyright renewal rights apply worldwide and are not limited to rights in the U.S. That's from the law firm of Loeb and Loeb. Another quote from the law firm of Mitchell Silberberg. For the first time, a federal court has held.
Okay.
There you go. For the first time, a federal court has held that termination rights under Section 304 of the Copyright Act of 1976 recaptured not only U.S. copyright rights, but also foreign rights as well, where the original grant of rights was for, quote, worldwide rights.
Well, I think it's fair to say the publishers will likely appeal. I don't know if the dollars in this particular case make it worthwhile for them, but if they appeal, I would say this one's a good one for the Supreme Court to look at. Well, if anybody disagrees.
I mean, surely, right. Well, I mean, surely we at this point have a split in.
Well, we have a Louisiana court.
We have a Louisiana court, right? Right. We have a Louisiana court, which is Fifth Circuit. So
it'll be interesting.
Anyway, folks, that's something we need to follow, and I am waiting on Stan Sucher to give us a good update at the CLE on his case summaries on this. So
absolutely,
I'll be doing further digging and posting some updates on my blog as well.
Well, we look forward to it, and we'll be probably talking about this case for some time to come, I would expect, if there's an appeal. So, well, listen. Just as a little bit of fun as we wrap up our episode this time around, there was an article about the Scorpions song, the big hit "Wind of Change," and this article explores the rumor. Apparently, this rumor has been circulating for a while that the CIA may have actually been involved in the authorship of this song as a kind of propaganda. And it raises questions about government-created work. Does anybody own a copyright? Has a publisher been collecting royalties on this song, without any real authority? Lots of that. Anyway, so we're just going to link to that article in here. Who wrote the article? Do you remember? Is it?
So I get a hat tip to my friend and colleague Darren Klumchuk, who's an attorney here in Dallas. But it also links out, or his article then has the link out to this podcast. That's a multi-part podcast discussing the journalist who followed down this trail. So it's an interesting listen. When you're finished listening to us, you can hop over and load that up in your podcast just for something a little fun to get you thinking about that.
Makes you wonder. I mean, there is a history of creative artists, actors, writers, directors having been employed by the intelligence services here and there over the history. I mean, I remember in World War II, there were some famous actresses who were agents of the government and things like that, but and various governments. But it's sort of interesting to think about, rock and roll music as an instrument of intelligence manipulating. Who knows? Here we are in an era where we're talking about AI manipulation of elections and foreign interference in the process and so on. So it's kind of an interesting time to revisit this question. Thank you to Darren, and we commend you to that other piece, and you get to decide whether this is how you want your tax dollars spent. writing songs. I can think of worse ways to spend
I'm telling you, I think it's pretty creative. I haven't listened to all of the podcast episodes, but it's interesting enough to take a listen and ponder it from both their creative journalistic perspective as well as our copyright perspective too.
Well, that does it for this episode of Entertainment Law Update. I thought it was going to go much longer than we did, but we're in right at the hour mark, so that's great. Anyway, as always, a big thank you to our loyal listeners for spending your time with us. And we appreciate it. And if you have feedback for us, and we hope that you do, you can leave it for us using that voice widget on the website over at entertainmentlawupdate.com, or send us an email, entertainmentlawupdate@gmail.com, Twitter handle X handle @entlawupdate. And, I just want to say thanks out. I want to give a shout out, I should say, to Alexandra Dickerman, who goes by Lexi, a listener, dare I say, a fan, who reached out to us, a couple of weeks ago and had wonderful, kind things to say about the show. She's currently looking at where to go to law school, if to go to law school, and so on. We wish you the best of luck, Lexi. Thank you for those kind words. Tamara, thank you, as always. Tell the listeners how to find you.
Yeah, you can find me online. Website is tbennettlaw.com and createprotect.com. At Tamara Bennett on most social media, TAMERABENNETT.
And I am Gordon Firemark in Los Angeles. My website, firemark.com, is the place to find me on the web. And gfiremark@firemark.com is my email. And gfiremark is the handle on most social media websites and things like that. So we're also going to say thanks very much to our team of volunteer contributors: John Janicek, our managing editor, Charles Thon, Alexis Allen, Violet Zhang, and Tasha Spear, and Dawson Holder. All were contributors on this episode. We thank you all. Congratulations to Tasha, who just let me know that she is writing for the Pepperdine Law Review and is looking for a topic right now. We're gonna help her find the right topic to work on.
Hey, so I'm gonna throw this out. I'm sorry I don't have the deadlines for our law student listeners, but they need, if they're looking for papers and a potential opportunity to win a all expense paid trip to the Grammy Awards, go over to Grammy.com and check out the paper requirements and submissions. They're going to be due a little quicker this year before the end of the year. So I will try and get that link for our LLM students and law students can submit papers for that. I know this week they were making a big announcement about it. And when you said that she's on Law Review. So she can go, Tasha can go check that out.
That's great.
And maybe get a 2-for-1.
Right. So that's great. Yeah. And listen, if you are interested in joining the fun as part of our family of contributors, please reach out at entertainmentlawupdate@gmail.com. And with that, I'm going to trigger our outro music and say that wraps up this episode of Entertainment Law Update. And that's loud. Anyway, thank you for being here. Thanks again for listening, and until next time, that's showbiz.